Everybody, welcome back to Jersey First TV. Elizabeth Nader with you again tonight, bringing back a friend of the program, attorney John Coyle. John, welcome back to Jersey First TV.
Thank you, Elizabeth. It's a pleasure to be back.
To our audience, you remember John before, I'm sure. He is an attorney in Morristown, fighting to help people retain their freedoms. And right now, as we face a lot of mandates, his job is becoming increasingly important. So we wanted to bring everyone up to speed. The last time we talked, John, we were talking about the employer's rights to mandate a vaccine, the employee's rights in the face of that, and all of the technical things that go along with it. Really, really important conversation that still stands, and people can go watch that. But since we've had that conversation, President Biden, I believe it was September 9th, announced that he was going to issue through OSHA what is called an ETS, Emergency Temporary Standard. And that rule was to apply to companies with 100 or more employees, requiring that the employees get the vaccination or have regular testing. So before we get into all of that, because it's a very important topic, which now is not only obviously, affected a lot of people, but we now see there's some rulings on it lately. Before we get into that, I want you to explain to people just real quickly, why use OSHA? What is an ETS, and why did President Biden think he could make it work through that avenue?
Easy questions you got on there, Elizabeth. The question as to why the president thought he could go through this mandate is, I don't think he thought he could. Far be it for me to tell the president what he's in. The president had been saying for a year, since on the campaign trail and ever since the election as recently as August, that the federal government couldn't mandate the COVID vaccine for people. And I think he's correct. I will tell you that his chief of staff was clear that this was intended to use OSHA as a workaround the fact that they couldn't do this.
Right.
So what this is, and this brings up the question of what is OSHA and how does an ETS and all these acronyms, and what do they mean? OSHA is the Occupational Safety and Health Administration. They're a federal agency that was created by a statute, law passed by Congress and signed by the president in 1972, that implemented this agency that's in charge with workplace safety. OSHA is the people that deal with everything from setting standards for factories to make sure you have guarding and other ways to keep people safe in the work. It's one of OSHA's job. If there's an accident in the work site, OSHA is reported. It's reported to OSHA, and they have to investigate it as they go from there. OSHA's played a vital role in everything for our country is to this point. The important part is OSHA is a regulatory agency. And people always ask the question, what is law? What is law? What is this? OSHA issues regulations. And the way administrative agencies work is a statute, and this is on the state or federal level. A statute creates an agency and authorizes them to take an action. And then that agency works by what they call rulemaking, issuing of regulations. Those regulations are not passed by Congress or passed by the state, not signed by the president or governor.
Right.
Instead, there's a regulatory process. And what that entails is an agency like OSHA issues preliminary rulemaking. They propose a long set of rules. It's published in something called the Federal Register, which used to be a book that anybody who did regulatory stuff, law libraries had volumes of these, legislators get these. Now it's online.
Right.
It's published in the Federal Register, and people are invited to come in and comment. Stakeholders are involved, and they comment, and there's a whole series of procedures. They comment, there may be hearings, there may be follow-up stuff, and at the end of it, they develop, based on the proposed rule, modified in theory by the comments and hearing that goes out. They then promulgate a new rule. And then it's then analyzed by various budgetary authorities to make sure what's the impact of this. And then it's issued, it's published, and then it takes effect. So that's how OSHA, like every other agency, does rulemaking.
Right. Normally.
Now, that whole process, from proposing a rule to it being implemented, according to OSHA's own website, takes between 26 and 63 months. It is.
It's long, and it should be.
That's exactly the most important part, because agency actions aren't actually passed by legislators and signed by the governor or president.
Right.
There needs to be procedural safeguards in place to make sure that these are done properly, give everyone a right and opportunity to be heard and all these other pieces of it. And you can't rush this process.
Right. The stakeholders need to weigh in, and supposedly they would listen to, read, take into account these comments on the proposed rule. So obviously that's not what happened here, which is leading you to explain why they took the avenue of the ETS, which is the emergency temporary standard. Now, not often this is an avenue that's been taken. Tell us when it has been and why choose this.
So an ETS is exactly that, an emergency temporary standard. And that's a procedure as part of the OSHA Act, the Occupational Safety and Health Act that created OSHA. And that allows, in the case of a dire emergency, there is a need for an emergency temporary standard, that because we can't wait for the regular notice of rulemaking procedures to come up with this. It has happened, I believe, 10 times in the entire history of OSHA.
Wow.
The most recent time before 2 months ago was in 1983. When OSHA issued an emergency temporary standard regarding asbestos in the workplace. And that's an important comparative for this, other than the fact that it's almost 40 years later.
Right.
That OSHA ETS regarding asbestos was rejected in court. And at the time it was rejected in court, the primary reason was that this isn't needed as an emergency standard.
Yeah.
People are developing the idea of what's permissible for asbestos. There's state and federal regulations and statutes about this. Workplaces are working towards this. There's a million ways that this is progressing. There's no need for OSHA to step in this emergent need to do this. And part of it is the fact that OSHA isn't necessarily the place to take care of this.
Right.
The courts recognize that there's other ways to implement this other than through OSHA issuing an emergency standard without the rulemaking protections that we just talked about.
Right.
So the last time was in 1983, and that went down.
Wow.
Until 2 months ago.
Yeah.
And you could draw a conclusion to say that there's a very valid reason that it hasn't been done in 40 years, is because it's an extraordinary remedy. But it is available.
It is available. And I think what's good about you explaining this is that it's a little confusing to some people what an ETS is, why OSHA, but you did mention that tweet from the chief of staff, which is an interesting insight into the administration attempting to find an avenue through which they could impose this mandate. Now, this mandate is no small thing for companies. It comes with a fine that's extreme, $14,000 per incident. They have to manage this mandate. They have to see it through. They have to add the HR component to it. It's no small burden on companies, especially who are not planning to do this. Right. So when this was announced, the time frame was given that employees would have to start getting vaccinated. And I believe January 4th was a cutoff. Is that correct?
That's right.
Okay. So by that point, these companies would have to have in place either testing or the vaccine proof from their employees, 100 or more. So what has happened now, John? We have this ETS. This is how the Biden administration chose to deliver this mandate. And in the past couple of weeks, we've had some movement on that. Explain that to everyone.
We do. I do want to implement one other correction. This didn't have a testing alternative. This isn't the New Jersey's version of this. This said vaccination, full stop. Now,
it never gave a testing. It never gave a testing option. Okay, so we'll get into that in a little bit related to Jersey, because I think what we need to do is compare and contrast the challenges there.
That's right. Yeah, right. Okay. New Jersey has its procedures in place under the executive orders from the governor going right now. And with respect to state workers and hospital workers and a number of other people, covered workers, it was vaccinate or test.
Right.
The OSHA standard deviated from that, which was it was saying vaccination or nothing. Now, not nothing. There's a little asterisk here. And the asterisk is, as we talked about at our prior show at great length, under the Civil Rights Act, Title VII of the Civil Rights Act, an employee in the United States who has a sincerely held religious objection to vaccination can assert same. And then the employer works on accommodations, whether they can reasonably accommodate that employee. That remained under the ETS. Okay. And the same thing for an employee who has a medical reason, a disability under the Americans with Disability Act, why they can't receive this vaccine. Those exemptions under federal law were still applied to the ETS. Okay. But other than that, every other person in a company over 100 employees or 100 and over was required to get vaccinated.
Okay, or face a fine. The company faces a fine. And so really this is the administration offloading this onto the companies. So we obviously knew this would be litigation. We knew this would be a court battle. And in fact, that's what's happened. The Fifth Circuit Court, so we saw an emergency stay from them, I believe on November 5th, which they then affirmed. So can you just quickly explain what that means?
Sure. And for people who are looking at these things in the court, I know it's very confusing at times. When you're challenging a statute, there's a 3-step process, or statute or regulation or some other government action. You have what you'd seek like a temporary restraining order. You're asking the court to step in on an urgent basis that there's a need to do it now and stop this from being implemented. And the next step following that would be what you call a preliminary injunction. That is, if the parties have gotten past the pause of the temporary restraining order, there's been more briefing, more opportunity for everybody to participate and be heard. And then the court determines whether to issue a preliminary injunction that would remain in effect through the remainder of the matter, at the end of which the court would determine whether to issue a permanent injunction. So TRO, temporary restraining order, preliminary, and then permanent are the 3 steps.
Okay.
The Fifth Circuit Court of Appeals in this case that we're talking about, challenging the OSHA's ability to issue this ETS, has essentially done the first 2 steps.
Okay.
They issued the first ruling you referenced was the stop immediately on the temporary restraining order.
Right.
Then the court reheard it and reconsidered it and went through everything. Now they had briefing, they had a lot of parties involved, people who were interested, stakeholders submitted briefing, and then the court then issued the order on the 12th that said, pending the outcome, the ultimate outcome of the case, the government is enjoined from enforcing this ETS mandate.
Okay, so now it needs to be heard. I think what's interesting at this point, if you look at the reaffirmation of that and the opinion that was written to support it,
Yep.
What sticks out to you as, I would say, the most encouraging point of that opinion to say that maybe this isn't going to survive? Or what do you think that we need to pay attention to in that opinion?
Right. And I think the court the court reviewed the ETS standard for a lot of different levels and found them all lacking. They talked about how there is no, under the history of OSHA and histories of ETSs, including the other ones that are involved, they all involved discrete emergent issues like this. And the court said, COVID has now been in our lives for 20 months or longer, and the dangers of COVID, and whether it's from shutdowns or lockdowns or modified procedures or employers and state level being required to mask or social distance or work remotely, this has been covered. And they question whether there is even a need for OSHA to step in the first place on this emergent basis, given the fact that we've actually all adapted to the workplace and living with a COVID world. That's one. They talked about that, whether it was there. They also talked about whether the ETS process in any way was a proper way of handling this. That this is intended to be an emergency that is designed to take care of this. And the court found that there was no history of this being used for illness, right? The idea of there being illness. As a matter of fact, there were court cases saying that ETSs are inappropriate for addressing things such as illnesses. They were designed to talk effect of something like there is a cadmium in certain components of things in the workplace. A prior ETS that was upheld was the court needed to stop in and step cadmium from being used in all those ways where people were exposed to it, employees and workers were exposed to it. And you need to step in because of that substance was linked to cancers and a bunch of other hard problems. There needs to be an issue right now. We can't let the market regulate this. We can't let the states regulate this. We need to do this on a temporary basis. And that's an example of something that an ETS is appropriate for. The court also took exception with the fact that this entire thing was intended as a workaround. I know we referenced the prior comments from the White House Chief of Staff, Ron Klain, and the court noted that in September 9th, he retweeted a tweet that said, OSHA doing this vax mandate as an emergency workplace safety rule is the ultimate workaround for the federal government to require vaccinations. Right?
Wow, there it is.
There it is. And when you look at that combined with a whole series of quotes where the president said, we can't require this. And if you listen to the prior time I was on thing, I think that's the correct answer.
Yeah.
They can't require this under a whole series of bodies of case law. And, the context in which this regulation was issued can't be taken apart from the actual text of the regulation.
Well, now stop there for a second, because I want to understand that better. I think we have several issues here that people are sort of combining. I mean, really what's being looked at is whether OSHA can do this, whether the
Yep.
ETS was appropriate,
Yep.
whether OSHA is the correct body to deal with this. And the other piece of it that most people want to hear and are dying to hear is that you can't do this at all. This is unconstitutional. This is an overarching issue, as you said, in the idea that the federal government can issue a mandate at all regarding vaccines. So we know what the court is looking at right now is really about OSHA, the regulatory body, the ETS, the use of the ETS, and whether that's appropriate. But what about the constitutionality of this? What about the Constitution issue? When will that be heard, or will it be heard in this venue?
Well, it won't be heard as part of this case, right? The courts, especially as you get into higher courts, they like to decide the issue that's in front of it. And by like to decide, they really need to decide the issue in front of it. And in this particular case, the court was looking at whether this ETS, it was appropriate, whether it was authorized by the OSHA Act, whether OSHA is authorized to take this action, and whether it's permissible in all sorts of other ways.
Right.
The concurring opinion from one of the justices, the circuit judge, Duncan, actually addressed this point at the end of his concurrence. And for everyone's understanding, a concurrence is when a judge says, I agree with the outcome, but I think that there's a different reason here.
Okay.
So when people look at opinions, dissenting, concurrences, joining, affirmances, at the end of the day, the Fifth Circuit Court of Appeals unanimously reached this decision. And one of the judges said, I reached this decision, but I also want to add something else.
Okay.
And that judge made a point of saying, whether Congress could enact such a sweeping mandate under its interstate commerce powers would pose a hard question. Whether OSHA can do so does not. And the court, that's the judge's way of saying this issue is not deciding something other than what's actually in the case.
Right. But it's a signal. It's a signal, right, John? It's a signal that I'm not sure that Congress has the right to do that. So we understand that this is one case focusing on really the means and the method, so to speak.
Right.
Just speak to your opinion from what you've seen and read in case law. Do you think Congress has the right, or the president has the right, to issue a federal vaccine mandate?
I don't think so, for a variety of reasons. One of which is, under a typical standing, the way we divide the federal government and state government authorities, states have been the ones who are in charge of general health and safety issues. And in the past, the Supreme Court has ruled on affirm that questions of vaccination are appropriate for states to decide. Okay, that's number one. The health and safety has never been something the federal government has done for the most part. There have been emergency things, as we've all loved for the last 20 months. On a big picture level, this is not something that screams that the federal government should be implementing. The federal government is trying, or may try, to implement this under an analogy to what we call the highway speed system. Right? The government has the ability under the Interstate Commerce Act, under the Interstate Commerce Rights,
right,
to tax and spend. And here's the easiest way of looking at this. The speed limit in New Jersey is 65 on the highway, on the interstates. You go to other states and it's higher. And you ask yourself, why is that? Well, it's because our government has said, we can't tell you what your speed limit is in your state.
right,
But we can tell you that if you set it over 65, then we're not going to pay you highway money to upkeep the highway.
right, of course.
And there's a lot of states who go, I don't care. It's not enough money anyway. I'd rather have my people have these rights. So when I was in South Dakota, the summer speed limit was 80.
Yeah, right.
New Jersey is 65. Of course, at the 80 speed limit, people are still going slower than they are in the Turnpike or Parkway. But putting that aside, there's a lot of things at play here.
Right.
The question the government would like to have answered is the vaccine mandate's the same thing. And we're seeing that with respect to CMS. Okay, I know we talked about the OSHA vaccine, the OSHA thing for this for a while.
Right.
The government also issued things through CMS, which is the Center for Medicare Services. That is the thing that is the equivalent of this OSHA that's directed to hospitals and healthcare workers.
Mm-hmm.
And what they said was, we can't mandate the vaccine for healthcare workers. But if you do not require the vaccine, the government is not going to pay Medicare money to patients at your hospital.
So just tying it to money again, just like they do with the highway speeds and all of that. It's tied back to funding.
Right. And the difference is, and this is the question that's going to be in front of some court deciding this, which is tying the highway money for speed limits the same thing as telling a hospital, if you do not discriminate against your employees and put in this vaccine mandate, we're going to have you turn away patients or deny them medical care.
Right.
And that's the question. One side is going to say, absolutely, this is entirely the same thing as the speed limit is set for safety. We know what the government points are going to be.
Yeah.
Speed limits are done for safety. There's a safety tie. There's all these reasons why healthcare workers should be vaccinated for COVID. It's the same thing as this, and we should encourage these places to require this for their patients. If this is highway money, then it is likely to pass muster. And if it's not highway money, then it's likely not.
Okay,
and that's decided by a court.
And that's going to be, obviously, those are going to be the arguments. So we've got that litigation probably coming, right?
Those are coming.
So right now, for companies that didn't want to implement the OSHA rule, they won't right now. They can stand down, they can wait. For those companies who were intending to do it anyway, many of those employees will be facing this path regardless of what happens. So it really depends on your employer. In New Jersey, the governor has mandated this across several different employee classes. So what is the difference between what he's mandating and what the Biden administration is trying to attempt to do through OSHA?
There's two major distinctions between this, and it's important to know who the court's action in the Fifth Circuit and now soon to be Sixth Circuit affects. Okay, and that's an important component of this. I'll deal with the state first. The state has applied this to various state and governmental workers across the board, and there's been discussions that the state would issue something modeled on the OSHA, that the state would issue its own executive order from the governor applying to employers of a certain size. That hasn't happened yet. Mm-hmm. It may, although it may be that these challenges are going to affect that one way or another. But under the governor's current mandate, it has been a vaccinate or test protocol,
right?
Which is what you were referring to earlier from this, which is that there are procedures in place. You can opt out for whatever reason. You don't have to have a legal exemption, as we talked about before. You could just decline. But if you declined, you're in part of a specific testing protocol.
Right.
And in a sense, the state is modeled on what the law would have been if you received an exemption. If you work for a private employer and you were granted an exemption from vaccination, it then goes into the accommodations phase.
Right.
And in practice, for many people, and this is obviously very broad, testing, masking, social distancing, remote working are parts of reasonable accommodations.
Right.
And I understand, we could spend 2 hours talking about what reasonable is, because
right.
what reasonable is intentionally squishy. It means different things at different times, different places, different jobs, different people, different workplaces. There is no black and white rule for what's reasonable accommodation, but reasonable accommodations generally include testing and masking. And as you mentioned, I've been dealing with a lot of these disputes in front of the EEOC, which is the Equal Employment Opportunity Commission, right. or the New Jersey equivalent, which is the New Jersey Division of Civil Rights, which is where we're bringing a lot of claims on behalf of people who feel they've been discriminated against.
And is that where you bring someone who's had a religious exemption letter declined by the company? Is that who hears that argument?
It is, and it's an interim step, and this is where we can go down a deep field. This is a whole separate time here. We got to, if you've been discriminated against, as you believe you've been discriminated against on religious or medical grounds for a vaccine mandate, you can go straight to court in New Jersey and say that the rights under the New Jersey's law against discrimination were violated.
Yeah.
The things we talked about before, Title VII, the Civil Rights Act, or the Americans with Disabilities Act, those are federal statutes. They both overlap and they both apply to your workplaces in New Jersey. You can't go to court and say you've been discriminated against under the Americans with Disabilities Act or the Title VII Civil Rights Act unless you take an interim step through one of the agencies who are implemented with acting as an overseer, call them a filter. Okay. Their job is to hear the claim, not necessarily decide the outcome of it, but decide whether or not it has merit, listening to the employer. And at some point, if you're there without an attorney, the Division of Civil Rights or the EEOC, if you're going without an attorney, the government can choose to bring that case for you. And the Office of the Attorney General, which is the Division of Civil Rights, will bring claims against employers for discrimination.
Okay.
If you have an attorney on your own, if you have an attorney instead of the agency attorney, they will give you what's known as like a clearance, where they say, you have met the standard of showing you have a claim going. We're going to let you go to court. And they sign off, the Division of Civil Rights signs off on, you have shown a violation of the federal statutes and the New Jersey, and you can go to court. Of course, if they say no, if they say you haven't met it, well, then you're done.
Then you're done. But I think the message to everyone is if you have been denied, there is a path for you to challenge this. So don't give up if that's the case. And I think one of the things we've highlighted here is that this issue of vaccine mandates, it's going to further divide the states, really, in terms of who is considered a free state and who's not, because what you're illustrating is the challenge of whether or not this can be done federally, but we know it can be done on a state basis. And so that's why we're seeing such different applications from state to state. So I want to ask you, just kind of as we close this up, because it's going to be changing, and obviously we'll have you back to update what the courts decide. This was moved to the Sixth Circuit, as you mentioned. So they will actually be in that third step where they're hearing.
That's right.
So when do we expect that to happen? What are the next steps?
I don't really know. It has just been assigned to the Sixth Circuit this week. When there are multiple cases in the different circuit courts of appeals on the same topic regarding the same statute, the same government interest at play, the government can request that they be consolidated, multi-district litigation, they call it. And they're consolidated so that you don't have, obviously, different judges deciding different ways and different piecemeal parts of it.
Right.
It's a lottery process. The court, they look at all of them, and the Sixth Circuit wasn't picked for any reason. No party picked the Sixth Circuit. It just was where the lottery wheel spun. It turned out to be in the Sixth Circuit.
Okay.
I will tell you that you could argue that the fact that the United States government, in opposition to this November 12th order, before the November 12th order was issued, after the TRO step, immediately sent a request to the court saying, we'd like this moved to a different circuit, maybe. I think they saw this coming down, and I think people overplay the idea that these circuits are political, or that they have, I've seen articles talking about these, a panel of Trump appointees did this, or a panel of Obama
appointees. Yeah, you do see that, right.
For the most part, that's overplayed, except, as we learned in the prior presidency, there were an awful lot of decisions coming out of the Ninth Circuit, which is
the famous Ninth Circuit.
That's right. That sits in California. Right. These circuits at times reflect sometimes the makeup of the courts as part of them. And in a broad general sense, the Fifth Circuit is considered more conservative than the Ninth Circuit.
Okay, interesting. All right, so that's where we stand today. So we really have to wait and see next steps. In the meantime, for those of you working for companies who don't want to implement this, we have a sigh of relief here. For the rest of you who are facing the state mandates, get your religious exemptions together and get a hold of an attorney to help you, right, John?
Absolutely. Now, and if you don't want to get an attorney, the Division of Civil Rights, the New Jersey Division of Civil Rights, is designed to be user-friendly. They're designed to deal with people pro se without an attorney. You can obviously go through it with an attorney, but they're designed there to help you work on your claim. You don't need an attorney. This, like a lot of things, this is a legal claim. You're probably well served to get advice from an attorney in the process, but you do not need one. And the New Jersey Division of Civil Rights does an excellent job at dealing with religious discrimination in particular, or medical discrimination, as we're talking about, as does the EEOC, which is the federal equivalent. But I must commend the New Jersey Division of Civil Rights for doing an outstanding job on this.
Well, it's good to hear, and it's good to hear people are winning and people are, getting their cases heard. So, John, before I lose my voice here completely, which seems to be happening to me, we're going to wrap this up. But I want to thank you so much. This is so important. Come back. We'll talk more about this. In the meantime, if people want to talk to you directly, how do they reach out to you?
They reach out to me. My email address for new client contacts is info, INFO, at coylelawgroup.com. That's my last name, CoyleLawgroup.com. We'll get back to you. Trust me, if we're expanding to have people. There's a lot of people who are looking for help and looking for answers and for sometimes just honestly a person to talk to in these challenging times. And a lot of attorneys are working together, help as many people as we can, and I'm glad to be part of the people fighting this fight.
Well, we're really glad that you are, because you're doing an amazing job, and we appreciate you. We appreciate your time. Thank you for educating us on this. We'll be watching it closely. We will definitely have you back, and I'm going to actually sign off now here before I'm completely out of my voice. John, thank you again for everything. And to my audience, guys, we will see you again next week. Have a